Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Michael Polito, Summer Legal Fellow at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So before we begin, I want to welcome our guest host, Michael Ippolito. He's one of our Summer Legal Fellows, spending the summer in DC. So Michael's a rising second-year law student at Albany Law School, and he's also the co-founder and former president of the American Post Liberal. Michael, glad to have you on.
No, thanks for having me on, Frank. I'm looking forward to these discussions that we're going to have today.
Yeah, we've got some good stuff to cover. And just a note to our listeners, we're probably going to start to rotate our hosts a little bit. As we mentioned, Mary Margaret Bush, my former permanent co-host, is now at the White House Religious Liberty Commission. And so my colleague, Joseph Clement, will be probably a pretty regular co-host, but we're going to hopefully start to have more of our fellows and allies co-hosts. So you're hearing a little diversity and not just me. So let's get to it. There's a lot of good stuff here. So this week, we're going to be covering the Supreme Court's June 16th ruling in the Diocese of Albany versus Harris case. Then we're going to stay in New York and cover some recent legislation that a lot of you are probably familiar with regarding physician-assisted suicide that's been in the news the last week or two. And then we'll finish up with a new Iowa law that's expanding access to release time from school for religious instruction. So some hard stuff, but we'll end on a high note. And actually, before we go into New York, we're not going to cover this as one of our main areas of substance this week, but I did want to briefly mention the Supreme Court's decision. By the time you're listening to this, it will be last week in the Skirmetti case. So again, I think most of our listeners have been following this, so I don't need to go into a lot of detail, but it's an important case and it falls within the scope of the things that we try to cover and pay attention to. So for those who maybe don't remember or aren't following closely, Skirmetti is the challenge to the Tennessee law that had banned certain surgical procedures as well as hormonal procedures that purport to treat gender dysphoria in minors in Tennessee. So that law was passed a couple of years ago. Lawsuit followed claiming that the law was a violation of the Equal Protection Clause of the 14th Amendment. And happily for us and for defenders of sanity, the Supreme Court was having none of that argument. So I don't want to go too far into detail. For those who are interested, by the time you're listening, Michael will have published a blog post that should be going live today on the Skirmetti case. I just wrote a piece that should be appearing at the American Conservative on the issue this week. So there'll be lots of coverage on Skirmetti. But I think briefly, it's really important to note what this ruling does legally. I think the precedent from Justice Roberts, two things that stand out to me in the majority opinion, and then I'll turn it over to Michael. But for one, I think it was made very clear that there's no suspect class that warrants heightened scrutiny going on here. This has been a common theme that when laws are passed that interfere with the LGBT movement, that the lawsuits purport that this is discrimination on the basis of sex, right? And this gets to my other issue, is this was what was going on in Bostock, right? Everybody kind of remembers that challenges to non-discrimination laws or use of non-discrimination laws for discrimination against people for sexual orientation, gender identity, were kind of shoved into this because of sex discrimination category. And that's been a problem and something that religious folks have been worried about, especially since Bostock. So in this case, same thing. And the court is very clear to say this is not sex-based discrimination in Skirmetti. They're saying there are two classifications that are being discriminated against, if you want to use that term. They are age, right? Because it's minors who are being banned from these procedures, and certain medical use or medical condition. That's the other class, right? The ban has nothing to do with sex. And Justice Roberts goes to some length to point this out, that first of all, a boy who's 15 cannot access these treatments. A man, same sex, who is 24 can, right? A woman who's 15 cannot, or a girl, a woman who's 24 can. There's no sex-based discrimination. Children of both sexes cannot do these things. Adults of both sexes can, not a sex-based discrimination claim, right? And then he goes further and talks about the medical condition thing, that clearly we're not discriminating against boys or girls because it just depends on the medical use. You can still get, for example, testosterone therapy if you have a bona fide, hormonal imbalance or deficiency that warrants that treatment. but you can't get the same treatment for gender dysphoria, no matter what sex you are. So I think that this opinion did a pretty good job of putting this to bed, at least for the time being, for equal protection cases, that no, like these transgender cases are not sex-based discrimination, especially not in this form when you're talking about laws passed to protect minors. So that's a big win. The other thing that I think Michael and I were talking about this yesterday off camera, but it doesn't kill Bostock, sadly. We're not close to that, but it does stop it in its tracks, right? Like Chief Justice Roberts says, we've never considered whether the logic of Bostock applies beyond Title VII, and we need not do so here. We're not going to touch it. He distinguishes this case from Bostock, and so again, we don't kill Bostock here or roll it back, but it was a very adamant, we are not going to continue that logic of turning sex-based discrimination into LGBT discrimination, at least for purposes of the Equal Protection Clause. So good ruling, I think really important precedent that it's going to set as we continue to have equal protection challenges in the face of LGBT kinds of cases. And I think it's just important on the ground that this allows an important branch of federalism, right? That states can pass state laws that restore sanity and protect the common good without equal protection challenges that, to me, don't really make sense. So, Michael, any comments before we jump into the other cases?
No, I'm just as happy with you with the Supreme Court ruling. I think we were expecting the court to rule in the favor of sanity, in favor of justice. So I'm glad that the court was able to make the good decision. And I just want to really stress the fact that the court's reasoning that did not say that transgenderism is a suspect or quasi suspect class really provides a great defense for the state legislatures to go in and to pass laws that protect minors from these life-altering surgeries, which I'll probably talking a little bit more in my blog post that's going to go up sometime soon. And I think that's going to give state legislatures, and I believe more than half of state legislatures in the nation already have bans on these surgeries for minors. So I think this is going to empower a lot more legislatures to pass laws that prevent these surgeries from happening. But again, the one downside, I guess, and I guess we always wish the court can do more, especially on these big decisions, is that the shadow of Bostock is still looming over these LGBT and these sex-related discrimination issues. And I do have a little bit of hope because Justice Thomas again stressed the fact that Bostock fails on its own logic. So I think there's hope that it's not going to be used in further cases and further decisions, especially with the court that we have now. But I think it's important that when the court revisits that issue, that it revisits that essential holding in Bostock to hopefully overturn it, so we can actually get some sensible laws about equal protections, because it does get wonky with how the court relates to LGBT issues and the level of scrutiny that it gives. So I just hope that the court can revisit these issues and give a clearer and more concise analysis of these issues. And I think we got one of them here. So just really happy with the decision.
Yeah, and this one's good because it's a constitutional decision, right? Bostock is a statutory interpretation of Title VII. And I doubt that we would, right, to unwind Bostock, you need a Title VII case. I don't imagine that we'll see a Title VII case where a secular employer, fires somebody for their LGBT status, and we just say, well, Bostock was wrong, so on the same set of facts, I don't think that's coming anytime soon, unfortunately. But what I do think we'll see, if I had to guess in the next year or two, is somebody will bring a similar challenge to what happened in Bostock, an employment discrimination case, but the employer will be religious, and then we'll have to deal with the religious exemptions and how that plays with the expanded non-discrimination precedent in Bostock. So I wouldn't be surprised if in the next year or two we see a case that's going to have to answer the religious question related to Title VII. So I think that's probably coming. Now, we're going to stay in Supreme Court precedent, and we're going to move over to this Diocese of Albany versus Harris case. Now, I think we've covered this, if not on the podcast, in our weekly email over the years. This is a very dragged out case at this point, but we have some major progress in the case, and it is directly related to the Wisconsin Catholic Charities opinion that came down a couple weeks ago now. So This was Monday, June 16th. The Supreme Court ordered that the New York Court of Appeals revisit the issue that was at play in the Diocese of Albany versus Harris case, about whether religious organizations should be exempted from, state regulations that require health insurance plans to cover abortion. So everyone's familiar with this. It's related to the Little Sisters of the Poor case with the contraceptive mandates. This has been happening in New York for year after year after year, where various versions of New York healthcare laws will require all employers to provide coverage for abortion, abortifacient contraceptions, procedures, things that are problematic to the religious conscience of many religious organizations. And we've had a problem with insufficient exemptions for religious orgs. So since 2017, New York State has mandated this abortion coverage for employers in their health insurance plans. Initially, there was an exemption that exempted employers with religious objections, but then the exemption was narrowed. This might sound familiar if you were following Wisconsin Catholic Charities. Narrowed to apply only to religious groups that primarily teach religion and serve or employ only those of their own faith. Now, the narrow exemption excluded a lot of faith-based ministries that, either serve all comers or do, works of charity other than teaching religion. So it was a problem. And the problem was just addressed a couple weeks ago in Wisconsin Catholic Charities, right? So if you remember, the holding in Wisconsin Catholic Charities basically comes down to, when you're giving an exemption, a religious exemption to some religious organizations, but not others. And in the Wisconsin case, the particular problem was that the state was saying, well, to get the religious exemption, you need to proselytize, right, to actively try to convert people, or you need to be serving only members of your own faith in your services. And in that case, they said, well, Wisconsin Catholic Charities is not doing that. They serve all comers. They're not actively proselytizing. Therefore, they don't exist primarily for religious purposes. And the unanimous decision from the Supreme Court in Wisconsin Catholic Charities, written by Justice Sotomayor, said that's an establishment clause problem. Like, you're making doctrinal choices and saying these kind of religions that do these kind of work, they count as religion and get the benefit. But these other kind of religions that do this other stuff, they don't count for our tax exemption. That's, for one, it was kind of an arbitrary line, but for two, that's government choosing one religion over another. So that was pretty severely rebuked by a unanimous Supreme Court in Wisconsin Catholic Charities. So flipping back here, the New York State Court of Appeals has constantly reaffirmed this mandate in New York, the Diocese of Albany case. Originally, they were asked to review their decision in light of the Fulton versus City of Philadelphia case. The New York Court of Appeals said, well, Fulton's inapplicable here. And now the New York courts will have to face squarely the realities of the Wisconsin Catholic Charities case, because it's right on point. It's the exact same type of discrimination between types of religious organizations that was struck down unanimously in Wisconsin. And the US Supreme Court clearly thought so, because they just issued on last week a two-sentence order saying petition of Diocese of Albany, right, granted, judgment vacated, case remanded for further consideration in light of Catholic Charities Bureau versus Wisconsin. So this is pretty clear. Like, now that Wisconsin Catholic Charities is here, you have to reconsider the case in light of this. I think it's always good to see these when the precedents start to very quickly trickle down, right? The decision was made in Wisconsin Catholic Charities. You can't have these random religious exemptions that cover some kinds of religions and not others. That's an establishment clause problem. Can't do that. So it's good to see how quickly the Wisconsin Catholic Charities case is going to have positive effects. And it's important because practically a lot of the organizations doing really important work in New York and around the country don't fit into this arbitrary criteria, right? Like, some of them might proselytize, but a lot of the time they don't. Like, right, the Sisters of Life, who are serving women in crisis pregnancy situations, the people who are running like Christian and soup kitchens out of their churches, or homeless shelters, these various things. Most of them, they're trying to live the gospel and do the corporal works of mercy, but a lot of them are not actively like going around to the people they serve and like forcibly trying to make them become Catholic or Christian or whatever. They'll witness, like they'll talk about the faith, but they're not proselytizing. And they're actively serving whoever comes to them. So it's not clear to me why this is a good line to draw, why those organizations don't qualify as primarily religious. So I'm glad that we've seen a pretty strong end to that. And I'm glad these types of exemptions are now dead on arrival after Wisconsin Catholic Charities. But one thing I will say is I would be very surprised if this was the end of this year's long New York drama. Don't want to, put a damper on a victory, but I think it's important when we see like very bold headlines like, Sisters of Life and Diocese of Albany vindicated by Supreme Court. Like, yeah, for now. But what this does is, the Supreme Court says, well, the state court decision that upholds this New York law, it was vacated. It has to be reconsidered by the state court. And that particular religious exemption and the distinctions that it draws is almost certainly unconstitutional in light of Wisconsin Catholic Charities. But I mean, if I were a betting man, New York's legislature is going to amend this religious exemption and try to figure out a different way to keep a lot of these organizations covered by this abortion mandate. And then we'll see the case continue. I hope I'm wrong. I hope they'll just, make the religious exemption broad and leave the poor sisters and these other groups alone and not try to force them to provide abortion coverage. But again, I wouldn't be surprised if this is not the end of the analysis. So, Michael, do you have any thoughts on Diocese of Albany here?
Well, this case is very close to home now that I've been going to school in Albany. I'm a quasi New Yorker now. And just for the listeners, I know it might sound confusing when Frank said Court of Appeals, but the Court of Appeals in New York is actually the highest court. And their Supreme Court is the lowest court. I'm not so sure why. That's the history of it. But anyway, that's just a technical point. But the fact that these Catholic nuns and these religious organizations are being forced to cover procedures that are just in violation of their deeply held religious beliefs. That is blatantly a free exercise violation. And I actually was talking to my constitutional law professor, Professor Bonaventure, about this case, and we were just talking about how this action by the government to make religious organizations and Catholic nuns, Christian nuns provide for abortion and contraceptives is just blatantly a free exercise violation. So I think even people with from all different political spectrums, they see that what's happening here is a blatant burden placed on their ability to freely exercise their religion. So I think this was another great win from the Supreme Court in terms of religious liberty. But I do have here, I guess, maybe a little bit of pessimism about the actions of the legislature because the point you mentioned earlier, how they really narrowed that exemption to only for groups that were proselytizing and or serving members of their religious community, how that came about, right? The exemption was actually broad at first, but abortion activists came into the legislature and they narrowed the exemption that forced Catholic nuns to pay for abortion. So it's just one of those issues that I think anyone who sees it and knows anything about, what nuns do to make them cover giving out contraceptives, providing abortion, I think generally people are not for it. I can really see the legislature pushing back. I don't think it will be likely. Maybe I'm a bit more optimistic there. But I do think in light of the Wisconsin case, that we have another victory here, and especially after Skirmetti too, that, I know recently the court's been kind of mixed when it comes to religious freedom, but I think we have some strong precedent here, and hopefully the Court of Appeals abides by the federal court decision.
Yeah. Yeah, that's a good point. And I will say that I think while the Wisconsin Catholic Charities case is so on point, right? Because the kinds of distinctions that Wisconsin Catholic Charities says you cannot draw are exactly the distinctions that the New York legislature drew. But I think it sets a wider precedent that says, like, if you're giving religious exemptions, you can't really pick and choose which religions they are, period. So I think like a quick chance to try to bypass it by switching, like, okay, it won't be about proselytization, it'll be about like what these religious organizations think about LGBT or whatever it is, whatever comes next. I think Wisconsin Catholic Charities might give us a broader precedent than we think, to really prevent these kind of arbitrary and discriminatory religious exemptions. So I'm fairly hopeful that this is going to be a pretty strong protection as well.
Yeah,
So
because either way, it places a really big burden on religious liberty. So I really hope that Wisconsin kind of just bypasses. No, if you give the religious exemption, then it has to be for everything that does not place that substantial burden on their ability to practice their faith. So I think this will go in our favor.
Yeah. And just to plug, we talked about Diocese of Albany, but Wisconsin Catholic Charities has big implications. I think we're going to still be watching that case and its trickle down effects in the months to come. So if anyone's interested in Napa Legal's analysis of this one, our own Joseph Clement wrote a blog post on Wisconsin Catholic Charity in the last week or two. That's available on the Napa Legal blog. And then I also wrote a piece at First Things magazine online on the Wisconsin Catholic Charities case. So we would encourage you to check out both of those. And now we will stay in New York and talk a little bit about this physician-assisted suicide bill, right? It's not a law yet. I don't think the governor
It's not
signed
law
it.
yet.
Okay.
No,
As
it's
of the
not law
time of
yet.
recording.
Yeah, as a it's good to stay in the Empire State and good to stay in Albany. But on June 9th, the New York state legislature in the Senate specifically, the assembly passed it a couple weeks before, but they passed a physician-assisted suicide bill. So it was technically legalized in the state of New York. It hasn't officially become a law because Governor Kathy Hochul hasn't signed the bill yet. And the implications of this bill is very dangerous because New York is going to become the 12th state, with 13, including in terms of jurisdiction, including DC, to legalize physician-assisted suicide. And this is really a disturbing trend that we've been seeing for a while. You hear a lot of the stories of the MAiD program that's up in Canada, and even across the pond in Europe, especially in England. There have been votes to legalize different forms of physician-assisted suicide, and there's different types of horror stories that comes out of that. And unfortunately, this bill is just continuing promoting this culture of death regarding physician-assisted suicide because it grants mentally competent or terminally ill individuals with 6 months or left to live to request life-ending medication, which they go and either the physician can administer to it or these individuals could then self-administer the medication. What's really alarming about this one is within 24 hours, the patient who got the news that they only have a couple of months left to live and they're terminally ill, they can commit suicide 24 hours later. There's no waiting period. In different states, there's usually some sort of psychological evaluation that the doctors have to give, or some other way to prevent the person from committing suicide immediately. Because for the average person, hearing news of terminal illness, it causes different types of emotions. So 24 hours later, people usually aren't in the right state of mind to make major life-altering decisions. But unfortunately, this legislation just gets rid of that entirely. And this is a step beyond what other states currently have. So New York likes to be either the best or worst in anything. In this case, they're trying to really be the worst in this area. Some positive, I guess, a positive outcome regarding the passage of this bill in the Senate is that the same day that the New York Senate passed this bill, the American Medical Association, which is an American professional association and lobbying group of physicians and medical students, reaffirmed its stance against physician-assisted suicide, and this was by a supermajority. So it was a large group of the doctors and medical students that came out against physician-assisted suicide and anything that was related to it. They have a strong conscious protections for their doctors in states where physician-assisted suicide is legal. So if there's a doctor and he's Christian or whatever religion that doesn't allow for physician-assisted suicide, he is allowed to bypass it. And this is a really good action that the AMA has taken. And they also were really stressing that allowing physician-assisted suicide would just be difficult to control. I know a lot of times proponents of physician-assisted suicide say it is going to be used in this very limited circumstances, but as we see, in Canada and Europe, and even states like Oregon that have physician-assisted suicide, that once it's allowed, it kind of goes off the guardrails. And you just have these stories of people who they're getting the medicine administered to them, and while as it's being administered, they regret it. Or you just have these stories that people try to depict the physician's suicide of a loved one, and they try to depict it as something that's very merciful and very loving. Um, but they kind of dismiss the dehumanization that's happening here in this problem, and I think a lot of times people aren't really considering the other implications of it. So it was really good that the American Medical Association took a strong stance against it. Doctors, as we know, they're held to the ethical principle to do no harm and the Hippocratic oath that they're not going to willingly cause harm. So I do think that this was a good thing to come out of it, but it's just really what we're seeing is just a step in the wrong direction. But is some advocacy that's happening in New York. Cardinal Timothy Dolan, the Archbishop of New York, he said that the bill is cheapening human life, and he's advocated against it. He's actually spoken to Governor Hochul about it, and Governor Hochul is a Catholic, so it's really great that Cardinal Dolan is leading the charge in the state of New York against this bill. But like I was saying earlier, that in our culture, we're really going towards, as John Paul II said, the culture of death, where people say that they have a right to die and they have the ability to produce human suffering as this form of false mercy. But what happens at the end of the day is, I think they first reject that that God is in control. Because they think that the terminal illness is terminal, and even though it may not be likely, but there is precedent of God, of these miracles happening and people overcoming terminal diagnosis. So people would just reject that and take life into their own hands. And what it leads to is just the devaluation of the dignity of the human person. And I think a lot of times what people don't consider with these laws is that it's going to uh, really be used to affect the most vulnerable communities. We're talking about the elderly. We're talking about people with special needs who don't have full control over their faculties, or people who are in socioeconomic, the lower end of the socioeconomic spectrum. That they are going to be the victims of it, not people who are suffering from an illness. It's going to be these people who really are on the outcast, kind of like the peripheries. I really hope that New York State, that Governor Hochul doesn't sign this law. She hasn't really given an inclination that she would support it, but I just think it's a tragedy. And I'm just thinking right now of I forget when the late Pope Francis said it, but that we live in a throwaway culture. I think it might have been Laudato Si, but I don't know if that's correct. But we live in a throwaway culture where we throw away the not just the what we own, but also the way that we view people, we view the marginalized. So I think unfortunately this legislation is just another step towards that throwaway culture, and I really hope that the good people in New York are able to push back and to have voice their concerns against this law.
Yeah, there's so much wrong here on every level, religious, cultural, as well as political and legal. So I'll try to limit myself here. But I mean, first of all, I think it's very troubling, both components of who is allowed to take advantage of this assisted suicide regime if it passes, right? The bill grants, you said, mentally competent, terminally ill individuals with 6 months or less to live. So I have problems with both sides. First of all, mentally competent, but you can initiate the procedure within 24 hours of the diagnosis. And from what I read, the doctors, you said, don't have to administer any kind of like psych evaluation. So
No, yeah,
I don't know how you're determining mental competency. Like when I think of mentally competent, I think of like capacity to stand trial, right? Standards of mental competency, which is very low. It means like you're not completely out of your mind. So if that's the same standard as like what's used to stand for criminal trial, then mentally competent is going to be include a lot of people with severe mental illnesses if they can still kind of know what's going on. So that's not a very comforting standard. And then the terminally ill thing, I mean, this is a problem of the modern culture's kind of worship of science to say that, well, if a doctor gives you 6 months or less to live, even just anecdotally, I know plenty of people who have outlived diagnoses by several years. Like this is not it's not a ticking death sentence that's accurate with any degree of certainty. Um, but these are all just kind of this is just making me think, was it what's his name, Henny Goodman, the comedian, right, said like, doctor gave me 6 months to live and then I couldn't pay the bill, so he gave me another 6 months. Like these numbers, they're not hard and fast. There's just so much wrong here. You could have people who are really not in their right mind, as you said. They've been traumatized by a diagnosis. They could have mental issues, and they're able to just make this snap decision to end their own lives. Which, and to your point earlier, this is the only other point I'll make here. This dehumanizes everyone in the process, right? Like the people themselves with the terminal illness, instead of like being surrounded by people who love them and cared for and really finding meaning in these last, days, weeks, months, years of their lives, they're being offered this, well, just kill yourself and stop being a burden on people, is basically what you're saying. Like avoid your own suffering and don't bother people, and don't, gum up the medical system with like extra dollars that could be used on people who are going to live longer. It really dehumanizes the patient. It also, you pointed to this too, very disturbing in the way it dehumanizes and warps the work of doctors, right? Who's like in the oath, right? Well, at least the traditional Hippocratic oath. I don't know what kind of oath they're taking nowadays. I know it's not the same. But do no harm is right at the center of it, right? The physician's job is to heal. And so there's something very cynical and dark about having doctors kill patients as part of their practice of healing, and of assisting health. So that's very disturbing. And then it's also, lastly, very dehumanizing to family, friends, to the people around them. This just creates, like you said, it furthers the throwaway culture, because it will, when you make this an option and then you start to make it a norm that people who don't have a lot of time to live and they're terminal, that they can just end their own lives and kind of get out of the way, you're going to dehumanize those people in the minds of their family and their friends and their communities. And you're going to create this culture where the young and the healthy are just kind of maybe leaning toward expecting that their terminally ill or elderly family members will kill themselves to like relieve them of the difficulty, right? Because it's hard. It's hard to have old, sick family members. You have to take care of them. You have to pay for them. You have to visit them. But this is all very human, right? Caring for our elderly, who, especially because they cared for us in our youth generally. But to turn them from like the elder members of our society who should be revered and cared for and dignified in their dying months and years, we turn them into throwaways who should take advantage of a physician-assisted suicide. It's very disturbing. So again, I think physician-assisted suicide as a whole is very disturbing. I think, like I said, I think it dehumanizes everyone. But also this bill in particular is particularly shocking because of the quick turnaround time, the lack of a psych evaluation. There's just, even beyond what's disturbing about physician-assisted suicide in general, there's a lot to be concerned with in this bill in particular. So hope and pray that Governor Hochul may veto it, but I think we'll probably find that out pretty soon.
Yeah, and I just want to make, I guess, one more quick point about this whole notion of physician-assisted suicide. Yeah, I think from a practical level, what we also see, and I forget which European country it was, but there was a young woman who was suffering from depression, and she ended up going into one of these physician-assisted suicides, and she got the medication, and she was able to kill herself just because she was suffering from depression. And as we know that we're really going through a mental health crisis in the country, especially after the COVID lockdowns, and this is general isolation that we're all feeling, the fact that young people are going, once they find out about programs like this, if they're not getting the proper treatment, the proper help, they're not, going out in the community, there's no community that's trying to support them and make them better. The fact that they have this option to end their own lives when they're so young, I think that is very dangerous. But I think this whole notion of physician is suicide, and Frank, you were getting at this, and I really agree with it, is that our notion of suffering is completely backwards. Is that we think that suffering is a bad thing and it's not sanctifying in a way, and that as a culture, we really don't want to face death, our own death. We kind of want a quick and easy death. We don't want a long, prolonged death, and we want the easy way out. But the traditional, especially the Catholic view of death, was to have a I guess have a happy death where you were able to make right with God and make right with everything. You see a lot of great examples throughout the Christian tradition. Death of Saint Joseph, even the death of saints like Blessed Carl, just having a peaceful death. And I think the culture, we want to move away from that. So again, like we said, we just pray that the right decision is made, and that this bill isn't signed.
Yeah. No, that's a great point. Obviously, suffering is a natural evil, but it's something that God can use for great good. And like the avoidance of it at all costs is not a healthy way to live. That's a great point. Now we'll end on something a little bit lighter after we've taken some dark journeys through New York State here, and we'll move to Iowa to wrap up. So we've covered these kind of laws in other states, but now we've got another law, another time release for religious instruction law passed in another state. So a couple weeks ago, Governor Kim Reynolds in Iowa signed House Bill 870 into law, which protects parents' rights to choose to send their children to religious instruction during the school day. So, like I said, we've seen this in several states. We covered it in Ohio a couple months back when they passed their time release law. But here we have another one. So this does a couple things. Students in public schools as well as accredited private schools can now receive up to 5 hours per week of private religious instruction during the school day. So this was a problem, particularly in Iowa. Before this, these absences from school, if a student was pulled out of school by a parent to go attend religious instruction, those would count as absences and they could count against the student's attendance. And so if enough of these absences accrued, if we all remember our public school days, right, you get a certain amount of absences per quarter per class and it's an automatic fail. So if you're out, once a week or for a couple hours, you could be labeled chronically absent without these laws, and action could be taken against the parents. You could end up with truancy actions to ensure the student was present in the classroom. So this is a real problem, and it still is. So the state legislature here laudably took action. So in Iowa, the new law says that a couple things. So the guardrails in place to be permissible, the religious instruction, it must be provided by a private organization. It doesn't occur on school property. The school isn't funding it or transporting students to and from the religious education, but it is now protected. So now Iowa joins several other states, Ohio, as I said, Montana, Oklahoma. There are a few others who have explicit mandatory provisions for religious instruction during the school day. So I just want to point out a couple of positive reasons that these laws are so important. First of all, I think they continue a really important positive trend of giving parents their proper rights to the education decisions related to their children, right? So we had and we'll see what happens, I think, fairly soon at this point, maybe this week by the time you're listening to this, in the Mahmoud v. Taylor case, right? We have this problem that's grown up where we have state education, right? You have the public school systems, and there seems to kind of be this growing, disturbing view that if you give your child to the state education system, then it's kind of just up to the state how to educate your child, and you've lost like your parental discretion. It's like, well, if you send him to school, you send him to school. It's up to the school what he learns. It's not up to you. That's wrong, obviously. So in Mahmoud, we saw the parents pulling their kids out of very disturbing sexual curricula, elementary school children. Can't repeat that enough. But right, and so the school pulled the opt out, and they said, well, too many parents are pulling their kids out during the day. It disrupts the day. And my response is, I'm sorry, if it's disruptive, that's fine. Like, parents, I think, should have a fairly robust ability to pick and choose when they're taking advantage of the state to assist them in educating their kids, right? So if they want to send their kids for math and science and English and not for sex education for third graders, I think they have every right to do that. I think Mahmoud is going to decide that. Similarly here, if parents want their kids to be in public school for 80-90% of the week, but then they want to pull them a few hours a week to have religious education according with their religious tradition, there's no reason that shouldn't be the case. I don't think it's all or nothing. I think it's very disturbing to have these systems where they say, well, if you opt into the public school system, you can't opt out of anything we're doing. You can't use other things during the school day. I think that's wrong. I think these mandatory time release for religious instruction laws are a really good pushback to say, no, if we want to send our kids to public school and we also want to pull them out a few hours a week for religious education at a private institution, that's fine. That's the right of the parent to make educational decisions for their kids. So I would also say that this law and others like it, they're important in some of their particulars, right? So the big change is that these are required time release laws at the state level. And this is different. There are other states that I think are still on the books that have like may allow time release laws. And what that does is it leaves it up to each individual school district, right? So you'll have some school districts that are friendly to this religious instruction, and then you'll have other school districts that say, no, well, we're not going to allow it in our school district. And these laws are statewide. They put an end to it. It's not may allow time release, it shall allow a time release. So that's a big difference. And the other thing is that while this isn't mandatory, the school does, the law allows schools to give course credit for religious instruction. And it also provides specific guidance to avoid biased decisions and when they are and are not going to award the credit. So it's not mandatory that your religious instruction counts toward your diploma. You can offer that. And so that's not perfect, but if they are going to award credit, they have to do it even-handedly. So the school can consider like the qualifications of the instructor, the number of hours of instruction per week, the methods of assessment evaluation. Like, is this just like happy story time? Or are they actually being tested and have a curriculum and so on? But they're not allowed to look at the religious content or the denominational affiliation of the religious program and deciding who gets credit and who doesn't. So that's also an important caveat here. And before I end on this topic, I just want to give a shout out, credit where credit's due, whenever we have friends, allies working on good things. So our friends at LifeWise Academy, which is nationwide, they've been doing good work on this for years. And really cool, I've gotten to know some of the leadership, some of the people involved at LifeWise. They, along with Napa Legal, they received a Heritage Foundation Innovation Prize a few weeks ago, along with us, and we met some of their folks at the event there. It was great. But they're doing really good work on this, and it's fascinating because LifeWise has now become a policy advocate for laws on this issue, but they didn't start that way. What they wanted to do was just be a resource to offer education, Christian education programs for like public school and private school kids who weren't getting it. And then they figured, oh, well, if we take advantage of these time release laws, that's great. Then we can have kids come during the school day and teach them. And then they started to get pulled into the importance of actually advocating for these laws. So often when you see a new state, like it was true in Ohio, I didn't look into Iowa, but usually when there's a new time release for religious instruction law at the state level, LifeWise is somehow involved behind the scenes. So again, I just want to point out they're doing great work both in the advocacy and in the Christian formation programs under these laws. So thank you to LifeWise Academy for being involved in this movement. Michael, anything you want to add before we close?
No, I was really in agreement with a lot of what you said, especially in light of the situation that's at hand in Mahmoud. And again, like what you said, we'll see, hopefully soon, we'll see what the court rules on that decision. But I just think that this Iowa law is a step in the right direction, especially with the fact that, like what you said with the wording, that it's not may allow, but they will allow. I think that what we're seeing right now with the whole issues with kids in school is that parents are looking for alternatives, homeschooling, classical academy, charter schools. But the reality is that a lot of these parents can't afford to send these kids to different type schools, or they can't afford to homeschool their children, so they have to deal with the public school. So the fact that these kids are going to have the ability to get some sort of religious formation outside of their regular public school curriculum, I think that's again a step in the right direction. And I think it's just another win for parental rights, and hopefully this allows for hopefully some more laws are passed that allow for greater exercise of people's religious beliefs. So no, it's good to end on a positive note after the dreariness that was happening in the Empire State.
Yeah. All right. Well, first of all, thank you, Michael, for joining me this week. This was a lot of fun. We covered quite a lot, and I think this is a good time to wrap up. From the Supreme Court to the Iowa State House. That's a good week. So
Yeah.
on that note, thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always encourage you to like and subscribe on YouTube or Spotify or wherever you're listening from. And we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We would particularly encourage you to be following in these coming weeks as the Supreme Court continues to roll out big cases. I think there is more to come in the next couple of weeks. So with that, we'll talk to you next week, and thank you for joining us. God bless you all.